Very, very good morning, friends. Today we are going to deal again with criminal liability in medical practice. For the purpose of same, it is very, very important to understand the procedure aspect of criminality in respect to medical practice. So let us understand CRPC in itself. I will share a Bayer Act for your knowledge. As I said, it is 484 sections. Every section talks about some or different thing. So let us understand CRPC, which was enacted by Parliament in 1973, what it says, because it governs complete criminal procedure. So many of the word which is coined across criminal practice is a part and parcel to this particular CRPC, like bailable offense, non-bailable offense, compoundable offense, non-compoundable offense. NC word commonly you have heard non-cognizable offense, cognizable offense. So try to understand the meaning of all this so that you can really guide your client in need whenever it comes. So what bailable offense is means an offense which is shown as bailable in a first schedule. So there is a schedule given where lawmaker has decided these sections going to be bailable or which is made bailable by any other law by time in force, and non-bailable offense means other offense. Now, for your knowledge, bailable means it is a right of a citizen. When it is bailable, I have got all the right to get a bail. Judges are going to follow the CRPC. They will not put behind the bar if it is a bailable offense. Non-bailable means it is a judge's right. If he feels that yes, this accused need to be sent out of jail, then he can. This is important for all you guys because arrest is only horrifying scenario situation in our country. If your client got arrested, then definitely your role comes, and to avoid the arrest, also your role comes. So section 41 was an old section where police officer without any order from magistrate, without warrant, arrest any person who commits the offense. So police officers were given an ample power, huge power to arrest under 41 and investigate the matter. That's the reason misuse of power was well known in this country. For any reason, for no reason, also many of the people were arrested and put behind the bar. The number of under trial has increased in the country. The jails were overloaded, and around 80% cases goes in acquittal is known by the lawmaker, and people remaining in jail for years to year and getting acquitted. The time which they spent in jail cannot be reversed. Knowing all this, the amendment done by the lawmaker in 2013, 2011, 10, 11, the amendment got done by the lawmaker to curb all this. And this was a great amendment done. That was a wise decision done by the parliament to avoid a crowd in jail, to avoid illegal arrest, to give a peace to the citizen and power to the citizen. This section was added by lawmaker, and this for you all is very, very important to avoid arrest of your people. When you know this section, you can very confidently share to your client that don't worry, you're not going to get arrested because law says that. You're not saying that. This is the law says. And what law says? The parliamentarian has added 41A, which says the police officer in all cases where arrest of person is not required under the provision of section 1, this is above, issue a notice directing person against whom the reasonable complaint has been made or credible information has been received or reasonable suspicion exists, he has committed a cognizable offense to appear before him and such other places specified in notice. So now it becomes mandatory to send a notice to the people where arrest is not warranted. It is said that whichever case, it could be 10 years punishment, it could be 7 years punishment, it could be, whichever where cognizable offense, but law implementer, that police officer feels that arrest is not warranted, issue a 41A notice. And what they say, Where such notice is issued by any person, it shall be duty of that person to comply with the term of notice. If a notice is issued to the guy, he should go to the police officer and support investigation. Where such person complies and continues to comply with the notice. So if your client is going for investigation, then he shall not be arrested in respect to the offense report. 57 very clearly says that within 24 hours, police officer need to present them to the magistrate. And this is very important for you because many of the time in a medical criminal liability, as we have seen that Honorable Supreme Court, with their guidelines as protected doctor in criminal medical negligence, and they said that expert opinion is mandate for taking action against doctor for criminal liability. So in 304 case, a case, or in such a cases, if your client calls that police officers called me in the evening, avoid it. Advise your client that he is busy and call the officer that he will come next day morning 8 o'clock or 9 o'clock. So that benefit he gets of 24 hours. Even he get arrested at 9 o'clock, by 11 o'clock, he need to take it to the court, or by 3 o'clock, he need to take it to the court, and he will get a bail immediately, being a bailable offense. And this is possible. I still remember a case where this gynecologist was called by a police station around 5 o'clock. He had not called me because prior to that, I was handling her case. And she was so confident that multiple times she went for statement, other things. She was very confident nothing is going to happen to her. But opinion came and she was called in police station. And then her mobile was confiscated and she told that you are arrested. She could able to call me through some phone because she was sitting there. She was terrified because arrest is terrifying thing. I reached to the police station. It was in Mumbai, so I could able to reach there. I spoke to the officers. They said, we can't do anything because we have already initiated the arrest. I said, even if you arrested her, being a female, law says that sunset to sunrise, you should not call her. And in bailable offense, keeping a lady in a night is definitely a questionable. I could able to meet the senior officers there. I told her in 304A, where in accident death bail is on the spot, table bail is given. So why not in this 304A case of my doctor? And I could able to convince these officers, and I got a bail, table bail. Midnight, I could able to bring this doctor 7 o'clock, 9 o'clock, something around out of that jail. She's still not forgotten me. It is almost 8, 10 years back. My friend, I will stop here today because I know more than this. If at all I bombard you, it will go out of your mind. And being a CRPC important, I will take a 2 or 3 session to complete that. But this sections which I have already guided you, my humble request that please read it because it is going to be very, very important for you to understand that. Let me take few questions for you. Deepak Chopra has asked, sir, do we need to submit original document or photocopy? Say under 91, police officer always demand the original copy because original they need to be. But my advice that if at all you are submitting original copy to the police officer because they are going to demand original, take a signature on a Xerox copy and stamp of police officer saying that original has been received from this doctor. Because if you don't submit or don't take a copy, tomorrow you will have no say in anywhere for defense. If at all original is lost by the police, many of the time it do happen. Original is misplaced by the police officer. Police officer do ask for the original. You can definitely give original, but take a copy of that. So thank you all, my friend. I